J.K. Rowling is standing firm in her defiance against Police Scotland and Scotland's new so-called hate crimes. "Arrest me," she said in one post after a series of posts on X, and in another said Scottish lawmakers seem to have placed higher value on the feelings of men performing their idea of femaleness, however misogynistically or opportunistically, than on the rights and freedoms of actual women and girls. Also saying freedom of speech and belief are at an end in Scotland if the accurate description of biological sex is deemed criminal. But even Prime Minister Rishi Sunak has essentially stood up for free speech whilst not commenting directly on any particular case. He did say that we have a proud tradition of free speech and we should not be criminalising people saying common sense things about biological sex. Clearly that isn't right. So in this video, I'm going to look a little bit more about the law because there's a few questions raised as to which section we should be looking at and how it might relate to other bits of legislation we have throughout the rest of the United Kingdom, for example, the Equality Act, back to that in a moment, and what might actually happen if a case like this went to court and whether there's any further repercussions. More about that a little bit later in the video. But first of all, if you're new to me, I'm Daniel Smith, a barrister of England and Wales, not an advocate of Scotland, but I can comment on the law. So I'd be really grateful if you hit that subscribe button. That's how I know my channel's still growing. About 70% of you don't. I'd be really grateful if you did, and ring that notification bell so you don't miss out on future videos. So let's go back to this piece of law and which relevant sections we're looking at. Now, of course, there's several different offences created here. There is an aggravation of offences by prejudice in one section. There's offence of racially aggravated harassment in another. The one we're really talking about here, which has got possibly the most broad ramifications, even for things said online and in your own home, is under section 4, the offences of stirring up hatred. There are broadly two offences in this section. The first is with regard to the stirring up of hatred against a group based on the group being defined by reference to race, colour, nationality or ethnic and national origins. And the second offence, broadly the same, but the characteristics that this is based on are age, disability, religion, or in the case of a social or cultural group, perceived religious affiliation, sexual orientation, transgender identity, which is the one that's caused a big stir online, or variations in sex characteristics, or as people might refer to, sex. But that's not what it says, which is one of the criticisms I've read online. Because if we move over to the Equality Act, the protected characteristics against which it would be unlawful to discriminate against a person are age, disability, gender reassignment, that is the legal process of going through a gender reassignment with a gender recognition certificate and so on, marriage, civil partnership, pregnancy, maternity, race, religion or belief, sex and sexual orientation. So quite clearly defining sex here. Now there's been a lot of discussion about the exclusion of biological males from sports, events and activities and competitions, and whether and whereby it is a legitimate means and a legitimate objective, if it's proportionate and demonstrated to be so, to exclude, for example, biological males from a female event. That might be proportionate, it might be legitimate, and they could demonstrate that that could be so. All of which could be permissible under the Equality Act. As a little bit of a tangent, this is a little bit akin to when an employer puts out a specific advert to cater for a specific group from whom they wish to recruit to improve their diversity statistics. That is perfectly fine and it's perfectly legitimate. It is not, for example, discriminatory against the other groups to whom they are not marketing these positions because there's a legitimate basis behind it and they can justify that it's proportionate. And all of that is set out within the Equality Act. But the distinction that people have drawn is that the Equality Act refers specifically to sex, whereas the new laws in Scotland under these characteristics, in respect of which the offence might be committed, in place of sex, I presume it says variations in sex characteristics. So presumably the characteristics of a male and female. But this is just another reason, in my view, why this law might cause confusion. And it's confusion that is really the heart of the problem here. Because what we are really looking at is whether a reasonable person would consider language to be threatening, abusive, or insulting. But there is a very specific difference between these two offences. It's only the first of which, that includes the words insulting, that being against the groups that are defined by reference to race, colour, nationality, ethnic and national origins, etc. The second offence drops the word insulting, and it's only that which would be considered by a reasonable person to be threatening or abusive in respect of these defined characteristics. But that, in my view, is not the end of the confusion, because judging by what I've read from the comments section on both X and on YouTube, the confusion is between what a reasonable person would consider to be threatening or abusive in respect of any of these characteristics. Now, as it happens, there has been a case in England and Wales that's made its way by way of case stated for a prosecution not under this legislation but under the Communications Act of 2003, specifically under section 127 sub 2, which is causing annoyance, inconvenience and needless anxiety to another. I'll come back to that in just a moment. But first of all, I do have a partner for this video, so this could be very useful to you. With all the recent headlines of people getting into trouble for what they say online, more and more people want to exercise their right of erasure. That means that they can insist that other companies delete all of their data and information online on their databases and so on. Now, whilst this is not a complete, unfettered and unrestricted right, you do have the right to require that these companies remove your data. Now, for that, I have a partner for this channel which helps you to do just that, which is called Incogni. Incogni is a done-for-you service, which once you instruct them, they will contact all of the data marketers and brokers that they have on their database and insist and require that these marketers remove your data from their systems, because they will sell on your data to other companies. And once it's sold on again and again, you lose control of it, and it might end up in the wrong hands, the hands of bad actors who might then use it to impersonate you and wreak havoc on your life. You probably weren't even aware that there are hundreds of these data marketers and brokers that gather your information together, put it together like a jigsaw puzzle, and the more information they have on you that they package together, the higher the price that they will be able to sell you your package of information onto other buyers. And this is sold on again and again. When you visit a website, it asks you whether you agree for your cookies to collect bits of information from you, including websites that you visited, things that you've searched for, and all of these kind of things. I've had many strange experiences myself, and I personally use Incogni to require that these companies remove my data from their databases. I get regular weekly updates from Incogni telling me which companies have complied with the law and deleted my information from their databases. And as I say, more and more people are taking this necessary step to protect their identity online. As a partner to Incogni, I have a fantastic discount at my unique link in the description below. Use my unique link and the discount code to make sure that you benefit from this fantastic deal. You get a 30-day money-back guarantee if you change your mind, but the peace of mind knowing that these companies will have to remove your data from their databases is going to be worth every penny. Not only will Incogni help to prevent spam phone calls and emails, but it will also help to protect you from scams, because fewer companies and people will have your information. It will help to prevent invasion of your privacy and, of course, identity theft. It's a simple sign-up process at the link in the description below. Incogni will do the rest. So check it out, you won't regret it, and thank you for your attention. Then comes the question as to what would happen if a case were prosecuted in Scotland and somebody believed that to be a breach of the right to the freedom of expression, Article 10 under ECHR. Now, as a starting point, Scottish criminal cases are distinct and confined to Scotland, with the High Court sitting as the appeal court and the final court of appeal in Scottish criminal cases, and not subject to review to any other court, save for the following. There's a limited right of review for the UK Supreme Court in cases which include an issue of devolution, whereby there might be or might said to be a breach of convention rights, ECHR rights. For example, the right to the freedom of expression, Article 10, ECHR. And in bringing such an appeal, there would need to be leave or permission from the High Court of Judiciary in Scotland, or failing that, special leave from the Supreme Court itself. But coming back to the case that I mentioned earlier, albeit prosecuted under the Communications Act 2003, the prosecution did stem from complaints about messages posted on Twitter at the time concerning a transgender woman who had a public profile. And in this case, the judge made an interesting and very important point about the right to freedom of expression. In particular, at paragraph 43, where the judge said the prosecution argument failed entirely when talking about these tweets, to acknowledge the well-established proposition that free speech encompasses the right to offend and indeed to abuse another. The judge appeared to have considered that a criminal conviction was merited for acts of unkindness and calling others names, and that such acts could only be justified if they made a contribution to proper debate. But in this case, the appeal was allowed and conviction quashed. Now, albeit there were quite a few intricacies in that case, which I won't go through in this video, I might do so if you let me know in the comments that you'd like me to go through that case. It's a very interesting case, and the broad spectrum of discussion is right on point here. But the judge made that very important point about the freedom of expression and the right to offend. So following on from the discussion about J.K. Rowling, and speaking generally and not about any one case in particular, I am of the view that this new law cannot really be used to prosecute these kinds of posts, because they really had not ought to be considered threatening or abusive in the way that the law really intends. In my view, this should be a particularly high bar. There should be a very real and credible threat and some sort of serious abuse. And even if we do see prosecutions under this legislation, remember under subsection 4, it is a defence for a person charged with an offence under this section to show that the behaviour or the communication of the material in the particular circumstances was reasonable. And that, of course, is another objective test. But to prove the prosecution, it must be beyond any reasonable doubt that this defence does not apply. Because any defendant, even in Scotland, as I understand it, only has to raise a defence and it shifts back to the prosecution, which, of course, in Scotland, it is a very, very similar prosecutorial code in that there must be sufficient evidence and it must be in the public interest. And then it is for the prosecution to disprove to the same criminal standard any defence relied upon. But that also raises another point. Is this even in the public interest to prosecute people for what they are saying online? Well, from what I've read about the number of comments and reports that are likely to be filed as a result of this legislation, prosecutions would also have to be in the hundreds and the thousands if they really did apply it in quite that way. So instead, I think Police Scotland are going to have to be very careful about which cases they choose, and they should really stand out. Because, of course, I am not in favour of abusing anybody, threatening anybody, nor communicating something that is so grossly offensive that it becomes obscene, oppressive and unacceptable, which is the general standard that we need to take things to for it to be unacceptable. So my prediction is that any prosecutions under this new legislation are going to be few and far between, and they are going to be the outlier cases, the most extreme cases, the most obvious, and probably most people would agree with. But for now, leave me your thoughts and comments in the box below. Please do remember to like the video and subscribe. I would really appreciate that. And as always, thank you for watching.